Good afternoon from Providence, Rhode Island. This is Zach Stoltz with Chisholm, and Kilpatrick. To my right is my partner Robert Chisholm, and to my left is Brad Hennings. We are here today to talk with you about Procopio versus Wilkie and a new case that was just granted certiori at the United States Supreme Court, the Kisor case, which we will end today with. But the topics that we're going to be talking about today, with help from my friends, is blue water Navy veterans and entitlement to benefits for them and entitlement to the Agent Orange presumption. Just by way of background, on Friday in Washington, D.C. at the United States Court of Appeals for the Federal Circuit, the court heard argument, and it was an en banc argument, which meant that all of the judges from the Federal Circuit, with the exception of two who did not participate, heard an oral argument on behalf of Mr. Procopio, and at issue in that case was what the Republic of Vietnam means and whether that phrase, the Republic of Vietnam, encompasses veterans who served in offshore waters of Vietnam. So in other words, those veterans who served, I don't know if you can see this, in the blue water that surrounds Vietnam, and if they served there from the period of the Vietnam War. And an en banc argument at the United States Court of Appeals for the Federal Circuit, as I said, involved all the judges, which was 10 in this case. So 10 judges got to ask questions all at once of both an attorney from the Department of Justice and an attorney that was representing Mr. Procopio. The oral argument was very good. Robert and I were in attendance at that argument. It was very, very interesting. The court was very, very interested in this important question, and we're going to dive into what this important question is. And we'll also kind of sum up on what the U.S. Court of Appeals for the Federal Circuit is, what this case could mean for veterans going forward, both Blue Water Navy veterans and maybe veterans as an entire community. So with that little bit of background, let's start with Brad. Why are we discussing Procopio versus Wilkie today, Brad? What is its importance?
So the reason it's important is because the case, Mr. Procopio contends that service in the Republic of Vietnam, which would get you a presumption for herbicide agent exposure, extends out into the territorial seas of Vietnam. Historically, again, out up to, I think, 12 nautical miles. And historically, the VA has only granted service connection for veterans who served on the landmass. Mr. Procopio says that that is an incorrect interpretation, and in fact, service in the Republic of Vietnam should go out, I think it's 12 nautical miles.
And so, Robert, when people talk about Vietnam veterans and Agent Orange exposure, it's relatively common knowledge. People who watch Vietnam War era movies and people who were alive during the Vietnam War and those who served in Vietnam are well aware that Agent Orange and other exfoliating agents were sprayed throughout Vietnam to kill the jungle, to defoliate the area so that the trees could be knocked down and the brush. So it's widely known that people who serve in Vietnam, the people that were on the landmass, are entitled to this presumption that they were exposed to these harmful herbicides. So can you talk about a little bit why the people that served in the blue water might have a case, and what the difference between the blue water and brown water veterans are? Because you start going down a rabbit hole a little bit when you talk about the Vietnam War of brown water veterans, people who served on the landmass, people who served in blue water. Can you clear that nomenclature up?
Sure. So right now, VA recognizes for the Agent Orange presumption that the following veterans who served during Vietnam were exposed. First, veterans with boots on the ground on the landmass of Vietnam. Even if they only just touched down, dropped something off on the landmass, and then went, say, back out to sea, those veterans are covered. Any veteran who flew into Vietnam and deplaned and got on the ground would be covered. Any veteran who served on the landmass is covered. In addition, there are a number of rivers in Vietnam, and any veterans who served in those rivers are also covered under the presumption. But what VA did is VA said, unless you were on the landmass or in one of the inland waterways, you are not covered. So all the veterans in the Navy who served offshore, who never took a boat or a flight and landed on the landmass of Vietnam, those veterans are not covered, and they're commonly known as the Blue Water Navy veterans. The reason they have a case is there have been some studies done that show that veterans who served in the Navy, and in fact it was a famous Australian study on this particular point that showed that those veterans had a high level of the dioxin TCDD, which is a byproduct from Agent Orange. And is in Agent Orange, I should say. It's a byproduct of when they make Agent Orange. I understand the chemistry, but again, I'm no chemist. But that is the dioxin that is very toxic, probably the most toxic chemical. And that is the reason the veterans get the presumption of a number of disabilities as a result of being exposed to Agent Orange. So there's scientific evidence that supports the fact that those veterans who served in the blue waters off the shore of Vietnam should be covered. But VA's position is there's no definitive study, and whether that's true or not really doesn't matter in terms of the interpretation that the Procopio case is going to make, in my opinion. Because at the end of the day, either the Republic of Vietnam includes the waters offshore or it doesn't. Whether there's a study that specifically supports it or not, I think is largely irrelevant, because when Congress initially passed the Agent Orange Act, the whole purpose was to avoid these kind of studies and create the presumption so veterans wouldn't be forced to prove each individual claim.
And it's worth noting that just because you served in the blue water and you can't show that you as a veteran set foot on the landmass of Vietnam, VA does provide a way for you to get service connection for your condition. And that is by being just like any other basically veteran. You have to show that you're entitled to direct service connection. So there are a handful of veterans, I would say a very small percentage, that can show that the ship that they were on in the blue water had Agent Orange on it, or that it came into contact with Agent Orange, or there was Agent Orange in their drinking water. If they can show that, then they are still entitled to service connection. So it's not the end of the game if you're not entitled to the presumption. The presumption just gives a veteran a big step ahead because exposure is already presumed and a number of diseases are presumed related to that exposure. And that's what the Procopio case basically wrestles with, but the Procopio case wrestles with which seems to be a really straightforward question. And so the Procopio court, the entire United States Court of Appeals for the Federal Circuit, which means that this case has already gone through the regional office, it's gone through the Board of Veterans' Appeals, it's gone through the Court of Appeals for Veterans Claims, and it was appealed to basically the second highest level you can go, which is the Federal Circuit. The only place higher is the United States Supreme Court. And it's in its last leg at the Federal Circuit because it's being heard by all the judges. And so it's wound its way for years and years up to this point on this question. What is the Republic of Vietnam? Does it mean, just as the VA says, the landmass of Vietnam and the brown waters within it? Or does it also extend to 12 nautical miles off its coast, which is the international law definition of of the Republic of Vietnam, or what the Republic of any certain country would be? So Brad, let's talk just a little bit, and Robert, about how Procopio got here and why it is that VA has been allowed for at least 10 years to say that when Congress said Republic of Vietnam, they only meant the landmass, and that is the Haas case. So you can talk just a little bit about that case, kind of its procedure and how it's governed where we are now. We'll go to Brad or Robert.
Robert, pass to Robert.
You'll pass to me. Okay, so there was a case called Haas that also involved a veteran. And this veteran served in the waters offshore Vietnam. And in that case, it went through the Court of Appeals for Veterans Claims, eventually made its way to the Federal Circuit. And in that case, essentially what happened was the Federal Circuit deferred to the VA's regulation and gave deference to it. And as a result of that, the VA had promulgated a rule that basically said only those veterans, again going back to the map, that served on the landmass of Vietnam or served in the inland waterways were going to be covered. And because the VA made a determination that the veterans who served offshore were not covered, then those veterans are not going to be covered. And that was the VA's rule for the last 10 years. But there's a little history to this rule. And that rule was, before that, VA actually recognized that those veterans who served in the waters offshore were entitled to some of the early presumptions created prior to the passage of the Agent Orange Act. But later on, VA essentially changed its mind and said, no, we're not going to cover those veterans. And so the Haas case deferred to the agency's interpretation by regulation, and now comes Procopio, who says, you don't even have to look at the regulation. The statute in the Agent Orange Act, the Republic of Vietnam, clearly means one thing: the landmass and the waters out to 12 nautical miles. And so that's why we're here today.
And that's why the court had to go en banc, because Haas was decided about 10 years ago, and it was decided by the Federal Circuit, which meant all of VA law, all of people that were seeking compensation and benefits, were governed by what the Federal Circuit wrote in Haas. And so it took this case to go all the way to the Federal Circuit, and the Federal Circuit had to be persuaded to sit with all of their judges so that they can change this precedential decision. So I'm going to shift it over to Brad. What would it mean if Procopio does overturn Haas? Where would we be if that happened?
And can I ask one question before that? Because I think it's important to put in context. We have some idea of the number of veterans who served in the waters offshore. And in fact, at the argument, I'll just throw this in, I heard the number of 50,000 veterans who served within 12 nautical miles. We've also heard a number of 90,000. And I'm not sure today we can say what the precise number is, but it will have a significant impact were the court to make this interpretation. And I'll turn it over to you, Brad, and overturn Haas.
I mean, I think the practical impact would be that a lot more, many more veterans would potentially be eligible for this presumption. I think there's a little bit of an issue as to what the Department of Veterans Affairs would do if the Federal Circuit overturns this. Whether they're going to say, well, we need to promulgate additional rules that take this into account. But potentially, and what we hope is that it would then allow those 50,000 veterans to automatically get that presumption to herbicide exposure, which opens up the presumptions for various diseases to reduce their evidentiary burden.
Can you give some examples of those diseases?
Sure. Some of the examples include different kinds of cancers, diabetes, mellitus, all the complications, some heart conditions, coronary artery disease, ischemic heart disease, and there's a number of other ones, but those are some of the biggest ones that we see for veterans.
And Robert brings a good point that the number of veterans that would be affected by this is somewhat in question. And the other thing that's interesting about this, as Procopio was argued on Friday, and as the court deliberates today, and as long as they deliberate, and it should be said that the Federal Circuit, in our experience, and we take several cases to the Federal Circuit, takes anywhere from 2 to 4 months usually to make its decisions. That is a usual. Sometimes it's very, very short and they come out within a week. That's very rare. And sometimes it takes them the better part of a year. But I would expect that this will probably be out by February or March is what I would think, just because they've been wrestling with this question for so long. But that's just a guess. But while this is going on, Congress is debating a blue water bill, which would have a similar effect to if Procopio were to overturn Haas. That legislation has passed the House of Representatives. My understanding is it passed unanimously.
It did.
And
yes.
Went over to the United States Senate, where it now languishes in committee. And one of the issues with why it's languishing in committee is because it is so expensive, because we don't really know how many people would be eligible for this. And my understanding as well, and I could be corrected by my two colleagues, is that it would also cover people who served in Thailand, some of those individual veterans, and not just necessarily only blue water people. And the last estimate that I heard was that it would cost the United States government about $1.2 billion to do this, which is some real money. And so that's something that Congress is wrestling with. And the court asked a couple questions about that, and I believe that we're going to put a link up so that people who go to our website will be able to hear the oral argument. It was a public record. You can hear the whole argument. It took about an hour. And you can see what all 10 of those judges were interested in, because there were a number of questions that they had for them.
I think there's just one thing to mention about the pending legislation, and that is, in addition to the House passing it unanimously, which is very unusual that you have such support, the Senate, the bill seemed to be moving well through the Senate until one thing happened. And that one thing that happened was the Department of Veterans Affairs came out and testified strongly against the bill. That was with the current secretary, Robert Wilkie. The prior secretary seemed to be for the Blue Water veteran. That was David Shulkin. But with a switch in the secretaries, the VA seems to have switched its position, and that is a large reason, we believe, why the Senate has slowed down significantly.
And there seems to be some resistance to creating more presumptions, at least on the Senate side at this point. And so that is something that bears watching in the future as well. Because, frankly, veterans who are exposed to burn pits at some point we think are going to need a presumption to win their claims. Those are very difficult claims to prove. And there's been some talk about creating presumptions down the line. So this resistance to this bill on the Senate side bears watching for future potential presumptions as well. I don't know if we have any questions from any of the audience members. No.
Oh, and people should also go to our website, since we've been mentioning it, which is cck-law.com, and you can read all about Procopio and many other veterans matters.
So we're also holding a holiday giveaway. So leave a comment below in Facebook, and you'll have a chance to win one of our CCK mugs, as you see right here. These are great coffee mugs.
Very great. Very handsome.
So.
All right, we got word today. I think that's it for Procopio for now, unless we get any questions. I'm sure that we will be talking about it again as the case comes out. We'll be waiting for the decision. That's what happens next for Procopio. It sounds like Robert has one more thing to say about before we move on to Kisor.
So, do we have any thoughts about which way it's going to come out? Do we have any opinions on that, or should we just?
Oh, we better not do them publicly.
We better not do them publicly.
I have an opinion.
Okay.
We have.
Well, the only thing I wanted to say, and that is, let's say for the sake of argument that Mr. Procopio wins. What's the likely step? What if Mr. Procopio loses? What's the likely step after that?
I mean, I think it's
guesses?
The guesses are, we think it's very strongly likely that regardless of which party wins,
right,
this case will be appealed to the Supreme Court. Now, whether the Supreme Court takes it or not is anyone's guess, but as it potentially involves a great deal of money, we think they may.
And so that brings us now to the Supreme Court case.
Yeah. We got word this morning that a case, another veterans case, the second veterans case of the year, of this term for the Supreme Court, was granted a petition for a writ of certiori, which is the method by which someone appeals to the United States Supreme Court. Only about 1% of cases that file petitions for cert are granted cert, and Mr. Kisor is one of them. It's Kisor, Kisor versus Wilkie. The other case that's going to the Supreme Court, which it is our understanding will be heard in late February, is called Gray. It is also a very important case. So as veterans lawyers, we're always excited to see the Supreme Court wrestle with veterans law issues. There have only been 4 cases that involve veterans benefits that have ever been taken by the Supreme Court. And this year, there are 2 more for a total of 6. So it's going to be an exciting time. So this is a jump ball. Who wants to start?
I was going to talk quickly about Gray, because Gray is somewhat related to Procopio.
It is.
So in Gray, the issue was, remember how we were talking about the landmass of Vietnam, the inland riverways? Gray is talking about the harbors and where the veterans who served in the harbors but didn't go ashore. And VA had a rule that said, no, those veterans are not covered. And the question in Gray is whether the Federal Circuit can review that regulation or provision once it's promulgated. So Gray is going to decide what the jurisdiction of the Federal Circuit is, and ultimately will decide whether or not the veterans who served and whose Navy ships went into the harbors but didn't go, those veterans who didn't go on shore are also covered. Obviously, if Procopio wins, then those veterans would be covered,
right? Because
it would extend 12 miles out.
And I think it really just shows how difficult it is to try to draw lines in legislation that was designed to be liberal in its application. Once you start drawing lines, you create, frankly, a big mess, and that's what we've had here.
And frankly, the VA has drawn the lines very narrowly.
Yep.
When it comes to the veterans,
as they could do it.
So the other case that we've been talking about is Kisor. And in Kisor, the Federal Circuit interpreted the word relevant in a regulation. And the regulation is 3.156C and allows veterans to get an earlier effective date for benefits if their claim had been filed in the past and denied, and the VA didn't get all the service records. So let's assume a veteran files a claim in 2000, it's denied in 2001, that's the end of the claim. But in 2015, the veteran reopens his claim with service records. As long as those are relevant service records, if the claim is granted, it can go all the way back to the original date of claim 2000. So this is a very important provision. It's a provision that many veterans have relied on to get all the benefits to which they are entitled. And the Federal Circuit said the meaning of the word relevant was ambiguous. And they deferred to the VA's interpretation, which was more narrow than the veterans' interpretation. And they relied on a case called Auer, A-U-E-R, from the Supreme Court. And there's a doctrine that if the VA's regulation is ambiguous, and the VA interprets it a certain way, or any agency, not just the VA, to be frank, but here we're talking about a VA case, we're going to defer to the VA's interpretation. Now, historically, my problem with this was that the VA is making a regulation. It should be a clear regulation so all of us can follow it. That means the veterans, the people at the Department of Veterans Affairs, the courts. But if the VA doesn't quite get it right, they get like another crack at it. And that's what Auer's about, in essence. That's the way I've always thought about it.
It's also a very political case. As soon as we heard that Kisor had been granted, I just put it into Google real quick and looked, and Bloomberg News already was on it and had a little blurb out about it, because this affects so much more than veterans law. Auer is a case that came from an older case that was decided in 1940. Auer was decided in 1997, and it was based on a case from 1945 called Seminole Rock. And it is something that both conservative-leaning judges as well as liberal-leaning judges are uncomfortable with, because it gives an almost unfettered power to the executive agencies to implement regulations without going through public notice and comment, and can be read as being something of an anti-democratic way for the United States government to implement its regulations. And so it is a very, very, very hot issue in all of administrative law. So it's going to be really something that not just the veterans community is going to be watching, but basically anybody who practices before the federal government in any capacity whatsoever.
In fact, with the Kisor case, there's been a number of outside groups that have submitted briefs to the Supreme Court asking them to take this case up, including people like the Department of Commerce, the U.S. Chamber of Commerce, as well as a number of other outside areas, because as Zach said, this can affect things as disparate as the Department of Labor Regulations, the EPA, Department of the Treasury. There's any kind of government agency that you can think of, this would potentially have a big impact. So it's a big deal.
It'd be a major way to restrict government power. And then transfer that power over to the judicial branch. So yes. It's going to be, it's really early. Like we said, cert was just granted this morning or over the weekend. So it's going to be developing. We think it's going to be argued probably in the spring sometime, March or April. So we're very, very excited about that.
So what's unusual is that two cases so far, and we say so far because Procopio may come down next year. It will come down next year. I don't think it's going to be decided before this year's out. The Supreme Court may have 3 cases on its docket potentially, but the fact that they have 2 is remarkable from the VA.
It never happened in my career.
It has not happened in the 30 years I've been practicing, so it's very exciting.
Any closing thoughts on Kisor or on Procopio? We will be tracking these cases and tracking all of the many, many cases that are pending before the Court of Appeals for Veterans Claims and pending before the Federal Circuit, including several CCK cases that we have argued over the past several months that we are waiting on, all of which are going to have major effects on veterans law. It is a very fast-moving part of the law and very, very fast moving for veterans. We are here to help guide people through that. So go to cck-law.com to see our work as well as some of our colleagues throughout the country work on these important issues. So with that.
So my only last thought is we're going to keep an eye on the bill in Congress, in the Senate. Sometimes things happen at the last minute, and that's still potentially possible. I'm not optimistic about it, but you never know.
Sand is running out of the
hourglass. But if anything happens and the bill goes through, we will certainly immediately update you, and we'll probably do a quick Facebook Live on that if that were to happen, explain the consequences of that.
All right. Oh, please remember to register for one of our handsome mugs in our holiday giveaway through Facebook Live. Thank you very much for your attention and listening. For Brad Hennings, Robert Chisholm, and Zach Stoltz, happy holidays. Thank you for tuning in.